Let's do some practice questions together, shall we? These are some legal questions. Looking at the new outline coming out for next year's change, it looks like maybe we need a little bit more of legal that I don't usually talk about these days. So here's some practice questions to walk through a few things. So first question, computer records indicating names and addresses of clients, as well as records of sales used in court as evidence against a drug dealer, is an example of which of the following? So computer-assisted crime, the computer is actually useful. The computer is part of the tools used to actually commit the crime. Computer-targeted crime, the computer is the target. So doing a denial of service attack against a website, computer-targeted. Computer is incidental to the crime. There is a crime, and in the middle of the crime scene, there is a computer. It wasn't critical to the crime. It wasn't how the crime was committed, but it is something that needs to be analyzed in the environment because it's in the middle of a crime scene. Computer misuse, that isn't one of the three main categories of computer crime. The first three actually are. So I would guess here that computer misuse would not be the right term because it's the computer is either helping in the crime, it's the target of the crime, or it is incidental to the crime. So here we've got a drug dealer and it's sales. So it's not the target. The computer is not the target of the crime. So B and D are out. So then it's either going to be A or C. A, computer is assisting in the crime, or computer is incidental. Oh, which one is it? I'm going to go for C. Yeah, computer is incidental because it wasn't that it was a critical element. They could record the sales, pen and paper and record the sales. It's just that the computer is part of how the crime was being committed, but it isn't a critical element to it. Where if like you're cracking cryptography, computer assisted would be more appropriate. All right, a system of law which is rule-based as opposed to precedent-based is most accurately labeled as which of the following? So major categories of law in the US, UK, Australia, some of the Caribbean islands, Canada, most everywhere of those places, the legal system is based on past English logic. So it's kind of where did the English settle or take over, whatever your perspective is. And that type of law is precedent-based. So it's what happened in the last court case, how was it interpreted? So the judge actually has the ability to interpret the laws, and that is actually known as common law. Another major category of law is civil or code. So you could say civil, civilist, code, Napoleonic code. This is really follow the French. So civil or code law, you're going to find it in New Orleans. You're going to find it in Quebec. You're going to find it throughout Europe, throughout much of South America. Civil or code law is the judge's job is to enforce the law. It's not an interpretation. Let me see how it works. Let me see how it fits. What happened in a previous court case. There's a judge, usually no jury. Common law, there's usually a jury. Civil or code law, the judge listens to the court case, takes in all the evidence, and then applies it to the law as they know how to do, and then says you're guilty or not guilty, and here's the punishment that goes with it if you're guilty. That's civil or code law. Tort, so civil or tort law, that is actually a subcategory of common law. That is where we find our lawsuits. And I know it because it says tort. So the problem with civil law is it could be the major category of law that we find in Europe, in South America, actually some of Africa, or civil, and it's the lawsuit category inside of common law. So it's a difficult way to say it. So code law, Napoleonic code would be easier, or tort if we're talking about lawsuits. Administrative is also a subcategory. It's actually a subcategory of law found in common law and civil or Napoleonic code. And that is where it's laws to protect a certain industry, like HIPAA in the US. So the healthcare industry is under administrative law. So back to the question, we have rule-based, not precedent. So precedent throws out common law. That's common. B is lawsuits, which is not the category. It's not the topic of the question. Neither is administrative. It's not a certain industry. It's not a certain thing that's being regulated by a country. So the right answer here is A, civil or code law. A case of simple libel in which the defendant is fined a sum of money to be paid as restitution is an example of which of the following. So given everything I just said, it's not administrative law. You have to protect health care data under HIPAA because the country says so. That's administrative. Religious law, you're going to find that in some of the Middle East. Actually, the last place that's truly under religious law is Vatican City. So if it's Muslim, you would call it Sharia. Religious law, it's going to be the Catholics in Vatican City. So it's not those two. So libel, criminal law, that's not a category of law. So criminal law is out. It's got to be lawsuit, which is tort law, sometimes called civil law. Let's do one more. The unique design and shape of packaging associated with a distinct product. Shape of packaging, so it's like the Nike swoosh or the emblems that you see on cars, whether it's the Mazda or the Volkswagen or I know that vendor, I know that product, I know who it is because of the shape of the packaging. So packaging could be the Coca-Cola bottle, something like that would get us there. So distinct product or brand, that's going to be our trademarks. Patent is something that is novel, useful, non-obvious. It's an idea that is going to be filed with the Patent and Trademark Office in the U.S. or whatever the patent office is in any other country. And it protects that idea for that inventor for a period of approximately 20 years. Copyright is like this question. This is my question. I own the copyright to this question, and I get to decide what I get to do with it. A trade secret is very different. It's something that is a secret to the business, a secret process or a secret way that something is created. Like what comes to mind is Coca-Cola's formula. It is a secret as to exactly what the percentages are. They have to tell us what the ingredients are, but they don't tell us exactly how it's all put together. But, it's a cup of here, a tablespoon of that. KFC chicken, the 17 herbs and spices that are in the original recipe. We could guess at all those spices, but coming up with the exact make of it is going to be guesswork because it's protected as a trade secret. So, right answer here, packaging of the product, that's going to be our trademark. All right, there's a couple questions for you. I'll do another one soon. See you in the next videos.